So, hi everyone. Good morning, good afternoon, good evening. Thank you for joining us today for TerraLex Presents the New Rules of Trade, Supreme Court Decisions, and Cross-Border Contract Risk. I'm Nicole Rudner, TerraLex's Director of Engagement. For those of you unfamiliar with the network, TerraLex is a global network of law firms that offers a unique advantage for corporations navigating the complexities of international law. It is a vast and diverse community comprising more than 22,000 attorneys from more than 130 independent member firms. We are spread across more than 200 jurisdictions, facilitating a unified, tailored approach to cross-border legal services for clients worldwide. The best view for you today will be if you hover in the little grid in your Zoom screen and change it to the speaker mode or multi-speaker if you prefer. We will be taking questions. You can put those in the chat and we will try to get to all of them during today's session. With that, I would like to turn it over to one of TerraLex's Global Trade and Policy Practice Group co-chairs, Aida Dismondy from Warner Norcross and Judd in Michigan, to sort of set the stage and introduce our speakers today. Aida?
Thank you, Nicole, and greetings to everyone. Well, today, and thank you so much for joining us, because today is what's bound to be a very promising exchange on trade and commercial contracts. As Nicole said, my name is Aida Dismondy. I am the co-chair of Global Trade and Policy here at TerraLex, and I'm also senior counsel at Warner Norcross and Judd, which is a law firm based here in Michigan in the United States. Our focus today will be in diving into the most critical decisions that courts have made recently, as well as administration has made, which is shaping the way how we do business, countries do businesses, but then also the commercial transactions are being shaped on a continuous basis. With that, I would like to introduce our distinguished speakers. I'll begin first with Anne MacGregor, who is a partner at Gecić Law, I hope I pronounce this correctly, with over 3 decades of experience in EU law, policy, advocacy, and journalism. She specializes in competition and antitrust matters with deep expertise in EU constitutional and legislative process, and represents clients before EU and UK courts. Next is Doreen Edelman. She is a partner and chair of the Global Trade and National Security Practice at Lowenstein Sandler offices in Washington, D.C., here in the United States. With over 3 decades of experience, Doreen specializes in CFIUS review, export-import, OFAC sanctions, tariff strategies, and cross-border M&A due diligence for tech and defense industries. She's also my fellow co-chair of Global Trade and Policy. And the next speaker is Homayune Ghaussi, a partner here at Warner Norcross and Judd in our Detroit offices with almost 3 decades of experience in supply chain litigation and commercial contract negotiations, as well as tariffs and disputes for automotive manufacturing clients across the United States and Europe. Homayune is also chair of the Supply Chain Litigation Practice Group and Supply Chain Industry Group at our firm. I'm also honored to call him my colleague. Last but not least, Nithya Nagarajan. She's a partner in Husch Blackwell's Washington, D.C. office, also with almost 3 years of experience in international trades. Nithya specializes in international trade remedies, anti-dumping and countervailing duty proceedings, M&A, securities, and supply chain issues for clients in technology manufacturing, and serving clients also within United States and internationally. With that, I turn the floor to all of you. Thanks.
Thank you, Aida. I have one correction. I have like 33 years experience, not 3.
Well, leave it to me and the internet. Thank you.
Thank you. So Doreen, shall you and I kick this off with
Absolutely.
the status of what on earth is happening right now? So before we kind of get into detailed questions, I'll do a very, very brief kind of lay of the land in terms of the timeline. So IEEPA tariffs went into effect in February and April of 2025. Immediately, there were litigate challenges at both the Court of International Trade and the DC Circuit. These cases were called 𝗧𝗲𝗍𝗍 selections and learning resources. The CIT issued a decision at the end of May, I believe it was May 30th, 2025, stating that the IEEPA tariffs were illegal. And that was closely followed, I think, within a couple of weeks by the learning resources decision by the DC Circuit. Both of those were appealed to the Federal Circuit. It was fast-tracked with briefing, etc., argumentation at the end of July, early August. August 27th, the Federal Circuit issued its decision, also confirming that the IEEPA tariffs were illegal, but with the caveat on the process questioning whether or not the Court of International Trade under Trump v. CASA has national jurisdiction to issue an injunction collecting those duties. That was then immediately appealed to the Supreme Court. That was also fast-tracked. Briefs were submitted in October. Oral argument occurred in November. Fast forward to February 20th, 2026, Friday night, Friday morning.
Always.
Supreme Court also confirmed and affirmed that the Trump IEEPA tariffs were illegal. And that has been the trigger for the last 3.5 weeks of a little bit of chaos. And we're here to try and make a little bit of sense out of that chaos. The one thing I'd like to add is in the interim between November and present, over 3,000 individual challenges by individual companies have been filed with the Court of International Trade, citing to, the 𝗧𝗲𝗍𝗍 and learning resources decisions that have percolated up through the court system. So that is the current state of the legal challenges to IEEPA tariffs. So one of the first things that we're going to address is, what does that mean? And I'll turn it first over to Doreen, and then we can, she and I will have a piggyback discussion.
Yeah, I think we should go ahead and let's start with the questions.
Sure.
So, Doreen, if I may, the first question, following up on what Nithya talked about, what is the current status of tariffs since the Supreme Court decision in February?
As Nithya said, the current status is chaos. I want to let Nithya answer this one because she can give you a moment-by-moment overplay of what is happening, and then we can all discuss what the different options are. And you will notice if you start Googling this, there's a lot of different information out there. And I had a client ask me yesterday, where can they go to read accurate information? So it's very important. Go ahead, Nithya, you get to do the outline.
All right, sounds good. So what is the current status? The current status is that the tariffs, IEEPA tariffs themselves, have stopped being collected as of February 24th, 2026. There is no precise refund process in place for anything that was paid from February 4th, 2025 through the midnight February 23rd, 2026. The reason for that is that the Supreme Court did not opine on the process of refunds. That mechanics of the refund process are now at the Court of International Trade. The mandate from the Federal Circuit came to the Court of International Trade on March 2nd, and the On March 4th, there was a hearing, and the court said to CBP, you must refund every single cent that has been collected on this. Customs, U.S. Customs has now asked for 45 days to set up a process, and there are weekly updates with the Court of International Trade on the progress of setting up that process. We anticipate that whatever comes out is going to be a not so simple refund process that's going to put a lot of burden on the importers who pay these duties. There's going to be a lot of mechanics involved, and it is going to take time.
And Nithya, I was very pleased that the Court of International Trade quickly jumped in and said to CBP, you've got 45 days, tell me what you can do. And now CBP has come back every 7 days and reported to the court of what it's done so far. Are you seeing in CBP's response some hidden delay tactics, the way they're setting up this structure where they have to approve each phase of what companies provide them in their new process?
Absolutely. Built into that process are nuances and mechanics of how the electronic interface called the Automated Commercial Enterprise System. It is a technology-based, computer-based system, and there are certain very precise mechanics that have to be followed by the importers to claim those refunds. And CBP has already said that there will be issues, there will be problems, and this is just a framework, and they will continue to refine it as it progresses. The other issue I see is that the court is viewing all of these entries as plain vanilla, that everything is just coming in as simple as, it can be. But those of us in the customs space know that there are multitudes of nuances. You have entries in different statuses. Not everything can be liquidated. And I think there's also a conflation of the concept of liquidation versus the actual refund. And the court and CBP, and you can see it in these declarations, they're somewhat talking at cross purposes. Hopefully that will get clarified as these weekly updates and as the mechanics of this get played out. But right now, there's built-in delays.
One comment before the next question. One takeaway, if you're just putting takeaways on the side, based on what Nithya has said so far, I think the most important thing is if you represent an importer of record that is entitled to money back, make sure that you're registered in the ACE system. Because if you're not set up, that's how your companies are going to get refunds. And as usual, there's a new process that all began in February. And that's the most important thing. You've got to be in that system.
Yeah, that's the ACH portal. That means that if you want to get electronic refunds, and that's the only way you're getting money back, register for that. And it's on the customs website. It's setting up ACH is very easy.
Perhaps I can jump in with a question then now. So if you are an importer entitled to money back, basically your message at the moment is the process for refunds is still being developed, get registered in the system, hang tight until the system's in place and you can apply. That's for importers, but we have really a broader issue. I mean, I remember on the day of the Supreme Court decision, all the news coverage was, well, there's been a Supreme Court decision, and in the next breath, the Trump administration is now going to apply tariffs using some other obscure provisions, because actually it's not very happy with the Supreme Court decision. So we seem to be still in a period of uncertainty where, okay, those tariffs are illegal and eventually importers will be able to probably get their money back. But, the restrictive measures for goods coming into the US, it hasn't gone away. And I guess there's talk of a new Section 301 case. What's that all about? Maybe you can enlighten us on that, because we still have a lot of uncertainty if you are trying to import goods into the United States.
If it's okay, Nithya, I'll start on that one.
Feel free.
And unfortunately, I think a lot of companies hope that this would be the end of the tariff wars, and I think it is literally just the beginning. As most everyone knows, the administration used an archaic balance of payments, Section 122 provision, which gets them until July 26, a new set of tariffs at 10 to 15%. That is like a temporary measure. It's arguable, it probably is illegal, but that's beside the point. So there's tariffs in place under this Section 122. We also, remember, have 232s. 232s from the Trade Act of 74 has been reevaluated by the Trump administration. It was a purely national security, defense-oriented, focusing on metal when it came out, which resulted in added duties. It now has expanded to national security, having this broad context of supply chains, advancing technology, capacity, just not what was envisioned when these laws were written. So these 232s are out there. They do not expire, and they get constantly renewed. Same thing with Section 301. You just mentioned 2 new cases. And again, this is really, really non-traditional. These 2 301 cases. Traditionally, 301 cases addressed specific trade disputes in Japan for intellectual property violations or unfair trade problems that the government set up in their structure. Or then Trump won against China, again, for systematic, specific problems in that country, unfair trade practices. The 301 is for any act, policy, or practice that negatively affects U.S. trade. Well, you see how that can be broadened, and that's exactly what they've done now. They have instituted one on false labor against 16, it's not even 16 countries because it includes the EU, so it's more than 16 countries. And then they have imposed 60 specific cases on another Section 301 to address this really broad excess capacity, and how they're going to tie that specifically or directly to the problems in the United States is out there. Is that unreasonable and discriminatory? We'll have to see. But the point is, these 301 cases are long-term, they're renewable, they're very broad, and they're considered Plan B for 232s and Plan C for 301s. And this is going to be a new state of play. I know that was a very long-winded answer, but jump in, Nithya.
Yeah, I also want to add in that, definitely the Section 122 tariffs are going to be challenged. There are also already multiple challenges being filed on the legality of that. Ultimately, I think fast tracking the Section 301 cases, because there is historically, if we go back to 2018, the reason why the China Section 301 tariffs have actually survived for so long is because USTR took the full time as mandated by the statute to conduct the investigation. So they had no process failures. This one, if they're fast tracking it and they want to have tariffs in place decided by end of July, there's going to be process failures. So that's going to be a legal challenge. So we're going to be in this, unfortunately, I feel like a gerbil in a wheel. We're just going to be circling around this over and over again.
Yeah, we talked about importers of record. Are U.S. retailers affected by these tariffs, and would they get a refund also?
Yeah, this is fascinating.
Yeah. You go first and then I'll jump in.
Getting calls every day on both sides of this. Retailers are not the importers of record in many cases. So they're buying from these suppliers that are the importer of records. And that means that the retailers cannot file a claim to get these tariffs back. They have to rely either on their contracts or their course of dealings with their supplier. Did the relationship with their supplier contemplate these tariffs? Did the supplier say to them, we need, on your invoices, here's the price of the goods plus whatever the IEEPA tariff price is, you pay us that. That way, there's a course of dealings that the retailers can send letters to their suppliers saying, I would like a portion of your refund because I paid this much in IEEPA tariffs. And you can see that there are issues with this. They've got to have good documentation and records. They have to make sure it's IEEPA tariffs, not 301 or 232 or 201 or whatever it is. They're also dependent on the supplier agreeing, because this is just a contractual basis, which you all will talk about in the future. So there are issues. And on the flip side, if you're an importer and your customer sends you a letter that says, I want my money back now, and you're like, we don't have our IEEPA refunds yet, and we may not have that money for a while. And by the way, we didn't raise prices because of the IEEPA tariffs. There could be a discussion. I had a client that imports or that manufactures and then sells in the US jewelry, and gold prices have gone up 165%. So their theory is we raise prices because of gold and other commodities, not because of these IEEPA tariffs. So you can see how they're going to be set up for litigation or mitigation or something on whether they should get this money back.
I'd like to add also that a lot of this is also going to be dependent on the contractual arrangement between the parties. Because in certain instances, the importers, when they passed on the tariffs, did provision for it in their POs or their terms and conditions. And in other instances, they didn't. So I will go back to a traditional trade remedies concept, which is under anti-dumping and countervailing duties. There's always fluctuation between the tariffs, and unless specifically provisioned for, there's no right to a downstream refund. And the entity that took the risk was the importer of record, has the primary right to that. They do not have to pass it downstream if they get a refund, especially in certain instances when they did not pass on the cost or the increase. And many companies did not. So it's a very interesting nuance.
Fact specific for sure.
Yeah, absolutely. I think we have time for one question before we turn it over to the second half of our
Sure.
conversation.
Sure. So given that we are where we are and there's just more and more uncertainty, more tariffs under different legal provisions being introduced, does that mean that US manufacturers are trying to reorganize their supply chains and trying to buy closer to home so they're not subject to so much volatility? Are any of your clients talking to you about, look, we need to reorganize how we do things? We're just too exposed if we're dependent on goods coming in and we never know what the tariffs are going to be, et cetera, et cetera.
The interesting thing on that is that, yes, the intention is to try to kind of shift and navigate the supply chain, but the practicality of it is that that's near impossible because there's upstream manufacturing in the US of high-end products, but the absolute raw material base is no longer there. So if no matter what, the US has shifted to being a net importation country for a lot of the basics. So the question is, you cannot shift all of that overnight to be in the 48 contiguous states practically. But what is happening is that you're strategizing to go to less targeted countries. for example, many people are actively sourcing out of China now because the likelihood is that China is probably going, the end game is probably going to get the highest number because so they're trying to see how they can mitigate it by potentially going to, you know, more friendly countries who are more willing to negotiate with the US. Doreen?
Yes, and I think companies are, well, I hope you're going to see more cooperation between the US buyers, the foreign suppliers, the middlemen. I mean, if nothing else, supply chain and strategic 5-year planning is so important. And if companies haven't taken a look deeply into their supply chain and don't understand where the intermediary manufacturers, if there are them, are getting their components from, they need to look at that because they need to look at the other tweaks they can make to reduce the pricing of their goods so they're going to at least reduce the amount that they're paying tariffs on. So we see companies considering more foreign trade zone possibility access using friendshoring. Maybe they're worried they want to get it out of Asia, so they're now considering getting it at least to Mexico. Of course, that's no guarantee either. They're looking at first sale rule. There's been a challenge to the first sale rule, but if companies, I don't think that's going to go anywhere. First sale rule is a taxing mechanism that allows you to use the price that the first manufacturer sells to the next person up the chain, and you use that price to base your US tariff on, even if there's another middleman in the process, thereby lowering your amount of duty you're going to pay on that product coming in. A country of origin is the last one I'll mention. Country of origin is risky because they can be challenged, but we've taken a lot of companies to say, your product's being made in Asia, but where is that essential component coming from? An example is hoses, rubber hoses. They're being put together in Asia, but that actual base rubber is coming from the US. That makes that product a US product when it comes back in the US, and we're avoiding the tariff on that. So I think, Anne, that you've got to have cooperation between all the different levels. And if you haven't taken the time to map your supply chain, it's very, very important. And
I'd
I
like to
think,
add that amongst all of this, strategic planning and shifting in supply chain, in parallel with all of the institution of tariffs, there's also significant uptick and increase in enforcement, not only at the customs level, but at the DOJ level with civil and criminal liability potentially for, basically alterations to the supply chain that are not factually supported. So you have to, I think, due diligence on everything has to be, airtight now because once enforcement starts, it's going to keep continuing regardless of the status of the tariffs. So I think with that, we should turn to the second half of our session. And of course, for all attendees, if you have follow-up questions, you can feel free to reach out to all of us on this team, as Doreen and myself, and Aida as well as on the import side. But now let's turn it over. Anne and Humayune, do you want to have a brief overview, and then we can get into questions?
Sure. So I should say that actually we're all here today because Homayune came up with the idea in the first place that there were issues now with contracts because of all these tariffs. And he has some very practical experience. Maybe, Homayune, you want to kick us off in this section. I'm going to give the sort of view from Europe, if you like, specifically the EU. But Homayune's had a number of very practical examples where contracts that are in place are becoming very difficult, hard to fulfill for one side or the other. And what do you do then? Can you get out of them? What does the law allow? What will the US court do? What's going to be possible in Europe? But maybe kick us off with a couple of practical examples that you've seen, Homayune.
Sure. This idea came about because of all the European companies that are clients and that we deal with and that are doing work here in the US. And, once these tariffs hit and once COVID hit and once, it seems like every 3 months we have a new crisis that we need to deal with. Once all these started to hit, what we started seeing quite a bit was a difference in view between our non-US companies who are doing business in the US and their thoughts on what contracts, how contracts work and how contracts can be reformed or amended or changed, or how you can get out of contracts when such issues arise, and how the US deals with those contracts. So quite often we've been faced in the past few years, and especially in the past year with tariffs, with questions arising as to, if when I entered this contract, my expectation was X, these tariffs have now made that expectation anything but X. What can I do to alter my contract? What can I do to reform the contract? There's often what I see a view that there should be fairness in the contracts when it comes to European-based companies that are doing business in the U.S. And then the reality that I have to give them that there is no fairness in contracts in the U.S. It's whoever can get whatever they can. Contracts are enforced here despite the fact that the bargain you bargained for may not be what you expected at the beginning. So I thought it would be helpful for our members and others to get an overview of the differences between how European laws may address those contract issues and how the U.S. addresses those. And of course, a lot of our answers today are going to start with my European wife's favorite answer that she says I always give as a lawyer, and that's it depends. You'll hear that a bit today in our discussion. But I thought that would be a helpful way to address these issues, to get a view that, this is what the U.S. does typically, because here, especially, we all deal, when it comes to tariffs, we're dealing essentially with contracts for goods, and the UCC applies. So it's one of those situations where, for the most part, regardless of which state you're in the U.S., the law is going to be the same. It's a uniform type issue where you're going to face the same type of pushback from courts, from your opposing party, et cetera. And I think one of the first questions we need to address is, when tariffs and unexpected costs like this arise, can a contract be reformed? And in the U.S., the typical answer is no. Unless you have negotiated for it, unless you have negotiated a term that allows you to come back and change, whether it be price, whether it be, who pays for import costs, unless you've negotiated a provision in the agreement that allows you to alter the bargain once a change like this comes into place, whether that alteration is by a change in price, a shortening of the duration, a termination. There are many ways to do it. Unless you've agreed to it, for the most part, courts in the U.S. will enforce contracts as written. We often, when we give presentations to our clients or industry groups, we quote a case where the court essentially said a bargain, even a bad bargain, is a bargain and it's enforceable. In the U.S. at least, there is no way to reform a contract when an issue like this arises. And as Doreen and Nithya mentioned, the chaos is out there, and I agree with Doreen. I think this is just the beginning. We're going to see quite a bit more chaos this year as we did last year, now that the challenges have come, to higher courts. And if your contracts are rigid and don't provide a way out, you're likely going to face costs that you did not expect when you entered into the contracts, unfortunately, without an ability to reform. And I think, and from my experience, at least, based on what my clients tell me, Europe might be a bit different in some of those ways.
Yeah, that's right. So look, I sit in Brussels, which is obviously the heart of the EU. That's where all of our EU legislation emanates from. But for those not familiar with how things are set up in the EU, you have to think of it very similar to the federal structure of in the United States Constitution. So it is a supranational organization, and under the various treaties that form the constitution of the EU, the member states of the EU, the 27 member states, have given the EU various competences. A lot of competences remain national. One of the competences, which is a sole competence at the EU level, is foreign trade, what we call our common commercial policy. So we have a single market, and although we still have national customs authorities, they are all applying one unified customs code, and our international trade laws are the same for the whole of the EU. That's EU level law, which applies throughout the EU. So when you import a good into the EU, whatever member state it enters through physically, you're then in the single market and your good is circulating around within our 27 member states because we have a single market and we're one territory for the purposes of international trade. When we want to look at contract law, it's quite a different story because almost no contract law has been harmonized at the EU supranational level. Today, we're really talking about commercial contracts, the only area of law where there has been some harmonization and reform emanating from the EU, which is then more or less harmonized throughout the member states, is really at the level of consumer law, which is not what we're talking about today. So when you want to look at a contract here, obviously you have to look at what is the governing law, and that will not be EU law, it will be the law of one of the member states, France, Germany, etc. And then you really need to, I mean, you're right, the answer is always it depends, because it depends on what is the governing law of the contract, and it depends on what you've negotiated in that contract. But in the civil codes, or I'm just going to talk today a little bit about Germany and a little bit about France, because they're two of the biggest economies. In Germany, we have the civil code, which is the Bürgerliches Gesetzbuch, the BGB, as we call it. And there is a provision in there, Article 275, which talks about the impossibility of performance in a contract. And essentially, if delivering certain goods becomes truly impossible, not just more expensive, but truly impossible, then there are ways in which the supplier can get off the hook. So what's important here is to note that just higher tariffs alone are not going to create impossibility, okay? They just raise costs. If you have export quotas or licensing blocks, that might create a genuine legal impossibility because you didn't get your license, or you didn't get, you're not part of that export quota. That could be an impossibility. But even then, the supplier is only going to be able to escape liability if they weren't at fault, if this was really extraneous to anything they did. So even if they, for example, didn't monitor quotas diligently, or they didn't file paperwork on time, then they'd have a problem. If performance isn't impossible, but requires grossly disproportionate effort, then there's a subparagraph of that provision in the German Civil Code, 275, subparagraph 2, which says, if it really becomes, you've got to exert grossly disproportional effort to still perform the contract, then you might be able to get out of it. So there are some escape valves there. They're not a given. Force majeure itself under German Civil Code is not actually treated. So For that, in Germany, you're relying on the United Nations Convention on Contracts for the International Sale of Goods, specifically Article 79. So if you really want to rely on force majeure, an act of God, so to speak, you've got to prove 4 things. So the event, in our case, where we're talking about new tariffs, yes, they're outside your control. But the next point, that it's not foreseeable, that's going to be kind of hard bar to jump, I think, because, you know, it will depend on when your contract was entered into. If it was entered into a long time before anyone ever thought that Trump could be president and introduce these types of measures, maybe you've got some type of argument. But it has to be not foreseeable when the contract was signed. If your contract's older, you might have more chances on this one. It has to have directly caused non-performance, the act of God, the new tariffs, so to speak. Many clauses require the event to absolutely prevent delivery, either factually or legally, and that's actually quite a high bar. And there needs to have been no other way that the effects of this could have been avoided. So, for example, no alternate suppliers existed, and you know, there was no other way to solve the problem. So, given the fact that trade and international trade policy is sort of changing almost every day and is so volatile at the moment, the foreseeability issue there is probably the biggest hurdle. I mean, that covers Germany. We can perhaps come back to France, but Homayune, do you want to maybe talk a little bit more about, you know, the ways in which things can maybe be sorted out in the US?
Well, and before I move on to that, I think your point on force majeure is a good one to address also. And I think it's similar to what you mentioned. The same type of elements apply here in the U.S. And, you know, one of the first things I hear, and force majeure is one of those things that I learned in law school and I thought I would never see it again. I see it daily now. I've written about it, I've spoken about it, and, you know, it's part of my life now. And, you know, what the clients typically ask, you know, well, this is an act of the government, isn't it force majeure, et cetera? And the main issues that come up, like you said, is foreseeability. Now, you know, prior to 2016, would it have been foreseeable that tariffs of these levels would be imposed in these ways? Possibly not. Post 2016, there could be an argument between 2020 and 2024 that maybe people did not believe that it would happen again. But certainly, if you entered into your contract since 2024, this is foreseeable. It is now, if you're contracting and you're at the start of the process and you're negotiating, the possibility of tariffs being imposed, at very high percentages, the possibility of tariffs being imposed one day and not another day, all of that is very much foreseeable at this point. So I think foreseeability is going to be a difficult element of force majeure to meet. And then the other aspect is, as you mentioned here also, when it comes to force majeure, the fact that your performance becomes more costly does not mean that your performance cannot be attained. So, you know, we see that often when it comes to port issues. If a port shuts down, or if the means of shipment that was expected under the contract is no longer available for whatever reason. What I often tell clients is, if your actual shipment is stuck in a port and you can't get it out, that could be a force majeure issue potentially. Because you are not able to get that particular shipment out, and that's the shipment that you need to deliver. If it is a matter of your shipment can't get through that port and it will now cost you more to get it through in a different way, to air freight it or otherwise, then that's likely not force majeure. And there are court cases in the U.S. that talk about increases in performance of 100 to 200% not being sufficient for force majeure. And the same goes for if you don't have a force majeure provision in your contract, then you look at the UCCs, commercial impracticability, and the same type of analysis applies. So when it comes to tariffs and increased costs, et cetera, it would be very difficult to use force majeure or those types of arguments to alleviate those contractual obligations. Now, as far as what can you do, what I have been telling clients, in the past few years, since 2016, is you have to plan for the worst. What I hope makes me a good advisor to my clients makes me not great in my life, because I plan for the worst in my life too. And I keep getting people keep telling me, what if it actually works out? Well, for my clients, I always tell them, your contract is essentially your prenup. You're very happy to enter into this relationship, but the contract is your prenup, and you're deciding how you're divorcing. And you better understand how that's going to work and who's getting what and how you're going to deal with it all. And you have to deal with the ugly stuff in your contract, and you have to provide for it. If you're quoting something at a price that is right at the level that you can sustain, then have a provision that allows you to change that price if outside effects, make it impossible to give that price still. Give yourself those outs. And if you can't give yourself that out, then decide, is that potential for a good outcome worth the possible bad outcome? Because right now, in the past few years, especially since COVID, we're talking about tariffs, but it seems truly that every few months there's another issue, like the Iran war right now and the Strait of Hormuz, that affects supply and affects your ability to perform your contracts. And you need to plan for that possibility in your contracts. And the best way to do that is just put in some outs. And then if you don't have outs, then talk to a lawyer before you talk to your opposing side, because we might be able to find you some outs. One of the first things we look for in contracts when a client comes to us is the contract a good contract? Is it enforceable? Can we find ways where we can say this contract fails as a matter of law, and then you can reform and renegotiate and start the process over? So it's important to have those types of planning, both the planning in place, and then when issues arise, make sure you take care of them in the best way possible.
Are you also sometimes just advising clients to give notice and terminate a contract if it's really so bad, and then go back to the drawing board and draft a fresh one?
Absolutely. When there's a possibility to do so in the contract, yes. If there's a termination that, with notice, absolutely. If there's no other way to do it, if the other side's not bargaining, then you get out. But you have to have a termination provision that allows for that. You have to have some other bargaining. One of the, in the past couple of years here in Michigan, one of the things we've dealt with, because we deal with so much auto supply, is auto supply is typically done on a requirements contract basis. Another one of those things that you don't get into often unless you're really dealing with an industry that works that way. And what that means is you don't know if the next vehicle this OEM is going to make is the famous Ford Edsel that did not sell, or the famous Ford F-150 that sells like gangbusters every year. Because you don't know that, there are typically no set quantities for purchase contracts in the automotive industry. And there are other industries that do this also. So instead, it's based on the ultimate customer's requirements. And under the UCC, the only term that is required for a contract to be enforceable is quantity. And if you don't properly address quantity, that contract could be not enforceable. So if you don't have a termination provision, one of the things we look at is, do you have sufficient quantity terms in there? Do you have sufficient other terms that are required by whatever applicable law there is to enforce that contract? And if the other side can't enforce that contract, then send them a termination notice and renegotiate. Because most times, like we said, like I think Nithya mentioned how, changing your supply base is easy to say, but it's not easy to do, because there's quite a long process in changing suppliers and changing where you're buying from, et cetera, because of that, you get bargaining power when you have a termination opportunity. And that bargaining power can allow you to either reform the contract, renegotiate the contract, or simply just to pass on the costs of tariffs, if that's all that you need to do at the time.
And
So
how
I
about
think
on the European side?
so. Yeah. I mean, it all comes down to the contract, and I think you have to build in clauses which are going to help you to just navigate changing landscapes. And I think, a hardship clause is one thing to put in, a term where price can be negotiated price can be adjusted in certain circumstances. Force majeure, although there are legal definitions of what that means, for example, in the German law and French law that we're talking about today, you can include specific things. You can list specific things in your force majeure clause. You could say certain acts of government or regulatory changes equal acts constituting force majeure. Certainly, you can do that in France. You can have language which takes you out of the sort of technical statutory definition in the civil code in France, Article 1218 of what force majeure is. So it's really about thinking carefully about contracts when you're drafting them and thinking, what if this happens? What would I do? Have I got a clause in there? Is my contracting partner prepared to be flexible on this? If you at least have got a clause which allows you to start talking and potentially renegotiate, then you're going to be in a much better position than if you don't. There's one other little aspect of French law which I think is quite interesting to mention. There's a sort of a doctrine of frustration or hardship, and this is in the civil code in France, and it has a long tradition going probably right back to the Enlightenment, where contractual solidarity, so to speak, is a doctrine that was developed sort of in the Enlightenment thinking, 300 years ago or so. The idea was that a contract is really the legal essence of any sort of cooperation. And coming through to the present day, there were major reforms to French contract law in around 2016. And French legislation now, contract law, recognizes a key principle that that is what's called in French the théorie de imprévision. And it's quite interesting. I'll just read out the provision because it says, if a change in circumstances that could not have been foreseen at the time of the contract being concluded makes performance excessively onerous for a party who had not agreed to bear that risk, that party may request that the other party renegotiate the contract. That party shall continue to perform its obligations during the renegotiation. In the event of a refusal or a failure to renegotiate, the parties may agree to rescind the contract on the date and under the terms they determine, or may jointly request the court to amend it. If no agreement is reached within a reasonable period, the court may, at the request of the other party, amend the contract or terminate it on the date and under the terms it determines. So that's actually a very practical and sensible provision, I think, in the French Civil Code, which could get you out of a spot if your contract's under French law.
And I think that brings up a really good point, and especially this being a TerraLex presentation, you need to consult people that are in the jurisdiction. You need to consult lawyers in the jurisdiction. That's why we're all here. And subject matter experts in the area, Doreen, Aida, Nithya, because that really matters. And I think, and what you just mentioned under French law, I've used that before in working with a client where we had a contract entered into in Michigan for supply out of France to Spain. And they put in a provision for termination that would be perfectly enforceable in Michigan, but absolutely not enforceable under French law. And we were able to use French law to gain an advantage for our client. And it was because we said, hey, this is in France. Why are you talking to a Michigan lawyer? I know you have a contract that was negotiated in Michigan, but let's get some French lawyers involved. And it truly helped. And I think that's very important to keep in mind, especially with issues of trade, issues of contract law. It matters what applicable law you use, and it matters what subject matter expert you use when problems arise. I like to think that I'm a good lawyer, but I'm a good lawyer in Michigan. I will not tell my clients what they can or cannot do in France or Germany because I absolutely do not know that. So I think that's important to make sure that we understand how the applicable law and the location of your performance affects your contracts in situations like this.
That raises a question that I'm seeing. Oftentimes these supply contracts are not under, I shouldn't even call them supply contracts, because they're really based on purchase orders and invoices. Are you seeing, I mean, is that an issue? Or obviously you're trying to get companies to use more contracts. Is that the solution? Are they better off if they're in that purchase order situation? Because then they can turn to, say, this French option and the civil code.
Well, that's a really good point, Doreen, and that's something we hear from clients all the time, that they'll come to us and say, I don't have a contract, and then we'll start asking questions about that, and they'll say, well, we have this purchase order, and that purchase order will have a set of terms that it references on a website, and at least under the UCC in the US, that is a perfectly fine contract. You do not need a document that you can hold in your hand with signatures from both sides for it to be a contract. We often go through a pretty significant, another issue that I learned in law school that I thought I would never use again, the battle of the forms, to determine what the contract terms are. But under US law, under the UCC, the whole point of the UCC was to get away from having a formal contract and to allow for commercial transactions to take place for the sale of goods with simply a purchase order and a quote, and whatever terms are there. And if there are no terms, then the UCC comes in and provides those terms. But those are perfectly enforceable, and as enforceable as a contract you can hold in your hands with two signatures on the last page. So it doesn't change things in the sense of what options you may have to get out. It only changes it in the sense that if, for example, you don't have you just have a purchase order that doesn't have a defined duration term, the UCC would allow for termination at will with reasonable notice. Those types of things can come into play, but outside of that, at least in the US, those purchase orders are perfectly enforceable as contracts.
Thanks. Okay.
We do have a couple questions from the attendees if you're all game. The first one was about the tariffs and the refunds in that process. And so I think it's probably to you, Nithya and Doreen. And essentially they're saying, how will that money be tracked once it's refunded to the importer, and how likely is fraud rearing its ugly head as well?
Doreen, I'd like to take the first shot on that one, if it doesn't matter, if you don't mind. So the importer of record, and it's important, that is the key person, entity, they have paid the tariffs. They know exactly how much they've paid. So they have to communicate that ultimately when CBP sets up the process, and they're going to get that refund. Like we discussed on this entire presentation, whether or not that goes downstream back to that importer's customers is dependent on a multitude of factors: the contract terminology, the kind of relationship between those parties to that contract, whether or not those tariffs were even passed through. So I don't think fraud is an issue here. It is very much commercial contracting, because there are these lawsuits and class action suits, alleging unjust enrichment. But honestly, unless you look at those contractual terms, there's potentially not a cause of action for a downstream consumer or customer to challenge this because, it's attenuated as to whether or not the pass through is a one-to-one, dollar-to-dollar effect. Anybody else want to add to that?
Yeah, the part of getting the refund is very clear who's entitled to it. The official importer of record. They've got to have documentation, and they've got to have detailed documentation and backup documentation. That's what's going to be required in this new process that CBP puts out.
Okay, and then we have another question. What is the status of the new tariffs that were imposed after the ruling? Are those being challenged?
Short answer is yes. There are already multiple challenges in court on those, and we're waiting to see how that plays out. It's too early in the process to, give an idea. But yes, there are already challenges out there.
And you may get money back on that, but that is not going to be before you've paid them. You're going to have to pay them through July before we know.
Any other questions from our attendees today or our speakers to one another? If not, Doreen, Nithya, Anne, and Homayune, do you have any final words of wisdom for your fellow members and our friends from the business community that are on today?
I would say dot every I and cross every T in every contract and track every penny, every cent of tariffs that you have paid so you have documented proof.
Exactly.
Oh, Homayune,
I guess I would say,
I'm mute. Yeah. Sorry. Go ahead, Anne.
I guess I would say, when you're entering into a relationship where goods are going to cross a border on a regular basis under a contract or a relationship that you're setting up, expect the unexpected. That's the world we live in now. It's changing every day. Build in some provisions that are going to give you flexibility. And if you've got a like-minded partner, they will recognize that, and they will also understand that it's good for both sides.
Right. And I think on that point, our clients need to understand that they need to understand their supply chain. They might think that they're buying from someone in the US and that none of this is going to affect them. But unless you completely map out that supply chain, it can affect you. Because even if the sub supplier raises its prices because of tariffs, it will make its way to you at some point.
I have one last piece of advice for everyone on today, which is consult your local counsel. You can utilize the TerraLex network for that. Finding the right person is often the hardest part, and we can facilitate that. You can reach out to any of our speakers, any of the TerraLex team, or simply visit our website. With that, I want to thank our speakers today, Aida, Homayune, Nithya, Doreen, and Anne, for taking the time to share their experiences and insights in this incredibly volatile world. I guess there is some comfort in knowing we are all in it together. With that, I hope you all have a great rest of your day and a wonderful week, and we will see you next time. Thanks, everyone. Bye-bye.
Thank you, everyone.
Thanks, everyone.
Thank you.